quorum. I'm calling the Charter Revision Committee of the Council to order. It is Monday, May 2nd. Vice Chair Mendez is present. Member O'Connell, myself, Angie Henderson, and Council Lady Johnson. I understand that Councilman Roten may be on the way soon to join us. Okay, colleagues, the first thing that I wanted, kind of first order of business, is it came to my attention at the end of last week that in an effort to just check, double check, cross T's, dot I's, belt and suspenders, MTA, in looking at the NDOT amendment, had thought that they might want to have some extra language, and hearing that, I followed up with Ms. Bem, who is counsel to MTA. Rita McDonald is here with us, Eric Byer from MTA, just to inquire, talk that through, what that would mean for us sort of procedurally, because we're at a stage in our process that's pretty late. With even one amendment, that means 2 substitutes. With 2 amendments, that could mean 4 substitutes in our packet and so forth. But I did, after speaking with Director Bland as well, just want to afford MTA, Metro Legal, NDOT the opportunity to kind of articulate the concern into the room and onto the record and have legal's response. So I wanted to start the meeting with that. And Ms. Bem, I'll recognize you. Yes.
Thank you for having us today. So we took a look at the amendment, and I knew it was late. We saw it about 10 days ago, and reached out last week, as Councilmember Henderson talked about. And we don't have any problem with the amendment itself, the NDOT amendment, but our concern has to do with the fact that there is no definition of transportation, of course, in this amendment. And MTA has very broad powers regarding transportation in the charter. So in particular, they have broad powers to deal with its own capital improvement projects. And that specifically comes from the Federal Transit Administration, in which it gives the Transit Authority money to spend. And every year we certify, I'm part of the certification process, and so is CEO Bland, to say that there's no law that prohibits us from taking this money and spending it the way that we do. And so what we propose, there was some amendment that would state that nothing herein in the NDOT amendment impacts or affects the powers and duties of the MTA according to its provisions in the charter. Since then, we've talked about, because there is some ambiguity about transportation and capital improvements in the language in both the charters, that it would be appropriate and helpful if this committee could just check in with Metro, your own legal counsel, and with the mayor's office to reassure, I guess, MTA and hopefully the public or anyone else who has a question about this, that this particular NDOT amendment does not affect and impact the power and duties of MTA as already set out in our charter. So we request that you just have the discussion that you're having, that you said you wanted to have, and that we welcome any input we can give or any thoughts we have.
Appreciate that. Subsequent to my conversation with Ms. Bem and Rita McDonald.
Rita Roberts Turner.
Why do I keep saying that?
I know Rita McDonald. I do know Rita McDonald.
I'm terribly sorry. I do apologize. Thank you. And we spoke. Then I did take the opportunity to call Director Bland, to call the administration, because Ms. Darby had also already spoken to the administration and legal, and just to kind of colleagues sort of, re-verify, just kind of go around that loop. And so subsequent to those conversations, I came to feel that what is understanding that MTA wanted to make this explicit in the charter by way of amendment, that it was indeed implicit, and that while not maybe the preference or the ideal, that it was adequate. And so I guess I would just ask the administration or Ms. Fox from legal, who did review this subsequent to the proposed language provided by MTA, double-checked this, and if you could just speak to that, please.
Sure. I'm Laura Fox from the Department of Law, and it's our opinion in the department that an amendment, it could be added, but it's not necessary. We don't think that the NDOT proposed amendment affects MTA's powers. It's not, certainly not intended to, and we don't think that it does anything to change the part of the charter that covers MTA. And so it's our opinion it's not really necessary.
Okay, and I guess what I would want to do, Ms. Fox, is just read into the record the proposed language that MTA had, and you could affirm that that language specifically was not necessary. Would that be?
Sure.
Well, okay. So as proposed by MTA for section 8.407, nothing herein shall affect the powers and duties of the Metropolitan Transit Authority as set forth in Appendix 4, Article 64 of the Charter of the Metropolitan Government of Nashville and Davidson County. So nothing herein shall affect the powers and duties of the Metropolitan Transit Authority.
Yes, that's the opinion of the Department of Law.
Colleagues, does anybody else have a question for MTA or legal? Vice Chair, you recognize.
Thanks. It's not a question. I just want to, again, for posterity with the video, from our conversations in this committee over many months now, and y'all can correct me if anybody feels differently, I think it is absolutely the intent of this committee for the NDOT amendment to have no impact whatsoever, no limitation, no alteration, no change on the rights and duties of MTA and WEGO under the charter. And so I just wanted to add that I think that's also the intent of the committee.
I concur with that. Yes, Councilman O'Connell, you're recognized.
Madam Chair, thank you. I agree with Councilmember Mendez. However, as someone who voted against that amendment, I think this episode speaks to how relatively incomplete, maybe not incomplete in text that yes, we can amend the charter in this way, but incomplete in the thoroughness that I think this committee was expecting to receive from the administration, something that more fully expressed both a vision of what the Department of Transportation was, maybe including definitions, and then also speaking to more completely the transfer of solid waste services. And so, I mean, I'm left even more satisfied with my no vote at this point with this discussion.
But you agree that there's
I do agree.
no impact intended?
I do agree, but I think, I mean, it's more, this is more about, I don't think we got, I mean, then I'm back to why did we even do this right now without the, you know, the full approach. It's just, the urgency of it is maybe a little lost on me still.
I appreciate that, Councilman O'Connell. Thank you. I think for those who are just joining us this first time, that is something that several of us on the committee have articulated previously. So. And
then, am I understanding you are not offering either one of your substitutes?
That is correct. In fact, so while I did ask Ms. Darby in an abundance of caution on Friday to go ahead and write up the amendment, after having the conversations that I had, so effectively, you know, what's been articulated in committee, I was able to have those conversations on Friday, and so when I then as well, and we can speak to this subsequently with Ms. Darby next on the agenda, but when I kind of thought through the order of operations and the level of complexity that we were introducing to the body at this juncture of the process, when really the window is closing from a prudent, you know, next steps, get it done, get it amended, get it substituted, that I had to balance the concern expressed by MTA, which I appreciate, and wanted to make sure that we addressed it robustly, whether through my calls or what's articulated in committee today. But as chair, I just had to balance, the majority of the charter revision effort. Amendment 1 is, it's sort of an existential issue, and it's not that, I concur with you. There are things that I had wished for the NDOT amendment, but at this juncture, I think I did not offer the amendment, so it is not in the packet, Councilman O'Connell. So this is just a discussion. It is not an item for our vote, but I did want to afford the platform on the record for us to articulate the intent of potential amendment, so that we would have that on the record. So with that, is MTA, NDOT, anyone else wanting to speak anything into the room or onto the record? All right. Thank everybody on that item, especially for their time. Ms. Darby, can I ask, before we move on to the discussion of Amendment 1B offered by Ms. Johnson, I wanted just to ask, colleagues are seeing the substitute 1, substitute 2. Can you just speak to why we have those? And then, from a committee standpoint, we will discuss the amendment and its merits and make a vote on the amendment. But then could you just go ahead and let us know about the substitute 1 and substitute 2 and why we structured it that way, what the next steps will be subsequent?
Certainly. So once the council has had a final vote, this document, the certified document from the clerk of the certified resolution will be transmitted to the election commission. And the idea here is to have a clean copy of all of the charter amendments go forward and to the election commission, so that we don't have charter amendment 1 with amendment, whichever amendment gets attached to it. And then I guess charter amendment 3, I believe, also had an amendment to it. So it's to clean up those amendments, incorporate them into the actual charter amendment language before it's transmitted over. Substitute 1 will be the resolution with, if approved by the body, the resolution with the Mendez amendment to Charter Amendment 1. Substitute number 2 is the resolution with the Johnston amendment to Charter Amendment 1. Since both of those amendments are competing, we have 2 substitutes that are ready to be moved onto the floor by Chair Henderson, depending on which way this committee goes or what the will of the body is.
I appreciate that, which speaks somewhat to the complexity of why introducing another amendment at this juncture would have been difficult. Okay, with that, and we can speak a little more procedurally to subsequent what happens at the end of our time, but I guess I would ask for a motion on Amendment 1B for purposes of discussion.
Can I move my own one? So moved.
Second.
Okay, thank you. Councilor Johnson, thank you so much. Would you just explain for the record, because we have to always remember, colleagues, sometimes the public is watching and this is the first meeting that they've watched. So though we've been through a process and talked about your amendment, we spoke about it last time, and we actually introduced it to the body, to the council last time for their reference and kind of absorption, and then deferred our resolution. But again, if you could give a brief summary to start the discussion, please.
Sure. So there's several parts to Councilman Mendez's amendment that is before us, and there's 2 parts of it that I am trying to change for the sole purpose of I want it to pass, because I feel like it's necessary for clarification, for just the general public to understand and feel better about their voice being heard and have it just a more clean process. We obviously have had a lot of litigation in the past couple of years that I think would have been avoided had this amendment been what we were being governed by. So what I was concerned about was the state legislation that was brought forth, I think, through the chamber, that would have done something similar to this, and the outcry of opposition to it was how far that would have moved the goalpost from a number of signatures on a petition standpoint. And it was subsequently defeated or tabled or whatever their terminology is at the state. And so in order to hear that and respond to that, what I have proposed is moving from 15% of the registered voter number to 10%, which 10% is what we have in the charter now. I do agree it needs to be on a more stable number, which is registered voters versus turnout of any election. And it also increases the amount of time from 75 days to 90 days, just to show that we are responding to what the concern was with with what was put forth at the state. Again, I think it's important legislation that needs to pass in its entirety. The parts of this amendment are not severable, and so I just want to pull back that goalpost just a little bit. It's still a significant move, but it is reining it back in a bit.
Okay, and all other aspects of the Big A amendment, as previously
All
approved,
remain.
all remain the same.
Correct.
So the differences are 10% of registered voters versus 15%.
Correct.
90 days.
Correct.
For signatures, correct? To
Correct.
obtain signatures rather than 75 days.
Correct.
Okay. Councilman Menez, do you want to be recognized?
Yes, I appreciate that. I mentioned last time, I appreciate the amendment, the spirit of it, for having a discussion about it. The thing that makes me want to resist it is I don't think the objections at the state level had anything to do with the citizens of Davidson County, and if they did, it's like a small minority of the citizens of Davidson County, and so I don't really have any interest whatsoever in being responsive to the people that raise the stink at the state at all. But that said, I want this to move forward with hopefully unanimous vote in the council, because I do think the specific target on signatures is not the most important thing about this. There's been, if you read the case law that's come out of the appellate courts over the last several years, there's a half dozen areas of litigation driving cost and uncertainty for the citizens of Davidson County, and the specific signature target is maybe the least important of the things. So in order to move forward, even though I really don't want to be responsive to whoever was complaining at the state, I'm going to be okay with the amendment.
Okay, appreciate that. And I think, previously in committee, I think I had spoke to just kind of the clarity and simplicity, frankly, colleagues, of every other county's 15%, and we're going to be 15% as well. But I think increasingly, as I have thought about it, I do appreciate Council Lady Johnson bringing the amendment, and I am leaning toward supporting it as well.
By the way, it's like 93 of the other 94 counties at 15%. Apparently, there's one other outlier also.
Thank you for letting me know.
I also wanted to give Ms. Darby the opportunity to explain a fun fact that I didn't know. About so if we can recognize her so that she can go through what has happened in the past with this threshold and numbers and all that kind of stuff, and that anyway, I'll let her explain it, but it just further justifies that Davidson County is a different animal than the rest of the state, and while sometimes I think we should have a lot of uniformity, there are some things that have proven to be very, very different and should be treated as such.
Well, just the fun fact, I think, that you're alluding to is that, so TCA 2-5-151 that has this 15% threshold in there was enacted in 1997, and at the time it applied to, it would have applied to Davidson County. Subsequent to that, in give me a second here to find my piece of paper.
Sorry, put you on the spot.
2005, it took effect in 2005. In 2005, Davidson County was exempted from that. So in 2005, we went back to our charter language regarding the number of signatories to the petition. So
So
I believe
all
that's
that
the
to
plan.
say, in recent history,
Yes.
there has been some change
Yes.
In that space. Okay.
Moving around, so to speak.
Does anyone else have a question for the administration, legal, Ms. Johnson, Mr. Mendez, or Ms. Johnson about Amendment 1B? Councilman Roten or Councilman O'Connell, do you have any questions? Okay.
Would move to approve.
Second.
All in favor?
Aye.
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 Okay. Unanimity, 5 in favor, 0 against, none abstaining for the Johnston Amendment. So at this juncture, subsequent to Ms. Darby's description, it is substitute 2, that is already drafted, contemplating a potential passage of Amendment 1B by Ms. Johnson. And so with that, do I have a motion?
Sure,
on-
can I
Yes.
mention
Yes,
something else
as
that,
well, sure.
I heard an additional comment today that I think is fine, but I just wanted to share it for everybody. I heard from Jeff Roberts, who's the director of the Election Commission, so not on the Election Commission, but the professional director of the Election Commission. He was sharing that the timeline in the amendment for his office to verify signatures will be tight for them. And we talked about it for a while. Well, like one of the things that's driven litigation is the current version of the charter is kind of squishy in how it defines the timelines of the amendment process. And multiple parties, including some election commission members, have tried to game the timing at different places. And so one of the things this does is laying out more precise timelines to keep the process marching and to make it clear that even if there's litigation, the process keeps marching. And so that, I talked to him about that clarity, and ultimately he didn't ask us to not move forward, and I told him that I would make sure to comment. I know that the professional staff of the Election Commission, I know we all see him in action out in the polling places, running elections. We see him when we get into a ballot, when we submit signatures, when we do our campaign finance. So it's a great group of professionals over there, and I do appreciate that they'll have to work hard to get the signatures counted. But in the end, I wanted to share the interaction. He did not ask us to not go forward. And he knew about the meeting today and decided not to come.
I appreciate you sharing that with us, and I think to your point, I think because of the litigation, volatility, just concerns, percent of registered, I can understand how for staff, in an effort to be professional and timely, just generally, however it might be authored, would want to understand and articulate, where they see the pinch points.
Sure.
So I appreciate him being in touch with you, and I guess.
With that, I can move the second
Okay.
substitute.
All right.
Seconded.
All right, and second. Any discussion about the second substitute?
Just double checking this is the right one.
Yeah, right. So you said that the substitute 2 is,
Substitute 2
Amendment
is the
1B.
one.
Let's just, substitute resolution. Yes. Okay, so colleagues, substitute 2 is the resolution with the Johnson amendment as we previously approved in committee. And so with a motion and a second on substitute 2, all in favor?
Aye.
Aye.
That's, again, 5 of us in favor. 0 against, and 0 not voting. Councilman Mendez, what I was going to say also in follow-up to the information that you shared is, colleagues, as we move into the meeting on Thursday, Ms. Darby is going to kind of get for the body just a kind of run of show a little bit, because, putting on the amendment, getting the substitute, and then there are 4 amendments within the resolution to amend. I think if we give the body a little bit of clarity or ahead on that, that'll be helpful. And then subsequent to passage, what I would say as well, for Councilman Mendez, or for those of us who have, I know myself for the NDOT amendment, myself and Council Lady Evans as Chair of Health for the Health Amendment, and I guess Councilman Pulley, Ms. Suara, and also Council Lady Evans in her role as Chair of Safety and Health. I think it will be incumbent upon us to kind of figure out from a public education standpoint how we want to kind of talk about and convey, really, as we would for the body, right, kind of distilling down what does this amendment do. That is in the for the ballot language, but our colleagues and just the community will be looking to us to make sure that we understand and can articulate what the amendments do. So subsequent to passage, we kind of move into a community education space. And so I would hope that we will kind of stay engaged and be thinking about that as we move towards kind of what happens next. Ms. Darby, can you also speak to if the charter amendment resolution as substituted were to pass at Thursday evening's council meeting?
We gotta take a vote before he goes.
Okay,
No, there's a quorum.
We have a quorum without him.
Oh, yeah. Never
okay,
mind.
yeah. Right, no, and we passed the substitute. Would you then please let us know, and do we need to take another vote at this juncture?
I don't think that you have another vote to take.
I'm sorry.
Okay, no, that's fine. Can you just tell us what are the next steps subsequent to passage on Thursday, a hypothetical passage, with the clerk, making sure it gets to the election commission on time? Can you just speak to the committee about your intent in that regard?
Yeah, the clerk will, after passage, the resolution does not have to be approved or signed by the mayor. So after passage, the clerk will prepare a certified copy. It will be, it's my understanding from the clerk, it will be emailed to the commission, the election commission, mailed to the election commission via USPS, as well as hand-delivered to the commission, just to cover all the bases to make sure it gets there.
Certified mail, right?
Certified mail, yes. And possibly return receipt, but definitely certified mail. And then subsequent to that, it'll be in the hands of the election commission to move forward and get it onto the ballot. But the clean language as approved in the substitute should help facilitate that.
Okay.
One other thing I thought
Yes.
I'd just get out there so we all are not surprised on Thursday. Each amendment will have to be voted on, each charter amendment will have to be voted on separately and receive 27 votes.
Yes.
And then the full substitute resolution will also have to be voted on and receive 27 votes. That's 5 votes for this one resolution.
And additionally, the vote, though, on the set, so it's 6 votes.
The amendment, yes.
Okay, all right, any other questions from Ms. Darby or anything else committee members want to share? Okay, I appreciate everybody's work on this and being here today, and thank you as well to staff and administration for being a part of this process up to this point. And with that, we are adjourned.
Thank you.